to another edition of Ask Michael Eline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel.
Hey guys, how's it going? I'm attorney Michael Eline, and most of you know I'm a lawyer, personal injury lawyer, licensed to practice law in Texas and California. I'm not licensed to practice law in Arizona, but I find myself covering the Lane Myers debacle and what's going on with him. And I don't represent him. I've never met the guy. I don't have any kind of a relationship with anybody that really knows him, really, other than just in passing and trying to understand what's going on with his case. And when I discuss the law, I'm going to be discussing general legal principles as it would apply in California or Texas. And other than that, it would be federal law and federal legal principles. So, I'm not trying to say that I'm an Arizona attorney. I don't have any skin in the game other than having a background in civil rights and appellate law. And that from what I've seen, I feel like Lane's getting railroaded. And because of that, I've devoted a great deal of my time and risked my reputation as well to support him, because I believe that lawyers need to take unpopular positions and stand for we the people. And the guy has been locked up for, I think, almost 2 months now. And I know from having done criminal defense and civil rights law that our so-called justice system many times will lock people up to try and force a plea bargain. And I have an enormous amount of respect for Lane in that he has not agreed to plea out. And it appears as though, and again, I don't follow this case every day. I have a really bad back injury and I've been on medication. But I saw some stuff the other day watching Reluctant Prophet and listening, as well as this is a public service that just shocks the conscience. And so I wanted to cover the story some more. Thanks, Lacey. Thanks for joining me. And I'm sorry, yeah, the gym does help, but I'm going to take a look at this. So I'm sorry says, have you tried methylene blue? So I'm going to try that out. I know you'd mentioned it one time before. So look, I don't have a whole lot of time. And so what I'm going to try to do is cover Reluctant Prophet's coverage, as well as this is a public services coverage of what's going on with Lane based upon audio recordings from the court in 2 separate occasions. And the last time I covered this case, Lane had, I think his lawyer's name is Parvin, had what I felt to be was a pretty good motion before the court based upon the statute, the harassment statute, being unconstitutional and as applied unenforceable. And I felt that his lawyer had some great arguments. However, I recently learned from watching these videos that it appears as though his attorney had like a conflict of interest or something. And also that this of counsel or advisory counsel thing appears to have been a way to prevent Lane from getting due process by filtering everything through his advisory counsel so he would not have access to motions. And then my biggest beef is that when he was incarcerated originally, one of the terms and conditions of his incarceration is that he would be allowed to use the law library. And of course, the judge said that on the record. I heard it myself, only to find out, and I'm still, it's disconcerting to me that there has been no law library at that prison apparently for years. And one would think that a judge that hears cases like that would have known that in advance. So it appears as though something happened between that time that I covered this, that Lane actually started getting access to a law library. I don't know how he did it. And when I heard his arguments, as you guys know, I disagree with Lane's outbursts and stuff like that, because if I did it, I would be disbarred. But look, he's not a lawyer. So, I don't hold it against him. That's who he is. And I think that the arguments that he makes are absolutely amazing. I think the guy's a genius. He's brilliant. And so I'm covering this because I'm concerned about our justice system. I was very blown away that I guess his name is Matt Walker, a prosecutor who apparently has a relationship with one of the alleged victims, is trying to do a petition to disable people from audio recording in court, saying somehow that prejudices the court. And so I tried to post my dissatisfaction with that, and I was denied my ability to post that on their public website. I got a lot of blowback. Where's Eli? Why isn't he posting? Well, I wasn't allowed to. And so I ultimately complained and was allowed to. But then I heard on one of Reluctant Prophet's shows that Matt Walker himself had to approve the comment. And then I saw that the state bar and that a bunch of court commissioners, basically the whole justice system, is supporting this guy's petition. And when I read the petition, it was based on facts that were not in evidence, that were not proven, it lacked any kind of foundation, and he was presenting his arguments as fact, as if it was true. And I would only hope that the Supreme Court, the cooler heads will prevail at the Supreme Court, and that the right of the people to audio record in court shall not be infringed. I mean, that has been part and parcel of the Arizona courts. And I've just seen the Californiization of Arizona with California judges, the Soviet Socialist Republic of California, California-style laws being passed in Arizona. And I'm hoping that the Supreme Court of Arizona errs in favor of we the people. And my long-term goal, I'm in Texas, but my long-term goal is to get barred in Arizona and start helping people fight for civil rights there as well. And it's just a matter of my health at this point. So I only have a little bit of time. Hey, SWE Observer, how are you today? I only have a little bit of time, so I'm going to try to blast through this stuff as much as possible, but I just wanted to lay that foundation. I don't know what happened with Lane's motion, or I think his name was Parvin's motion, to get that statute ruled unconstitutional. But I was hoping that the judge would rule on it, because I think that was a winning motion. I've said from the very beginning that the way that statute is written and the way it's being enforced is unconstitutional if it had been handled in California or Texas, for sure. And I just think that everything possible is being done, and it has the appearance of impropriety by government officials who don't like Lane Myers, basically railroading him. That's the way it feels to me. It has that feeling. And I think a lot of people agree with me. And so I wanted to cover what I've learned in the last couple of days. Hey, how's it going, Brandon Mitchell and Chevy? Yeah, I know, Miss Dolly 6500. That's what I see that happening too. I see, starting with Hussein, and now with Sleepy Joe, this effort of them trying to turn the whole United States into a single party state like California, so they can get crackpots like Gavin Newsom in charge, appealing to people's emotions rather than individual rights and what matters. And so I'm officially christening Lane Myers as Braveheart today. I believe that he has earned the crown of a modern American Braveheart. And if you guys know who Sir William Wallace was, he fought against the King of England and injustice. And I am very, very impressed with what I've seen with Lane. So whenever you guys hear me say I don't like his approach in court, it doesn't mean that I don't like Lane or his substantive arguments. I just think when you cut people off and you belittle them, it doesn't lend itself towards winning. And it could prejudice a jury against you as well. So just keeping that in mind, I want to get into this, doing an attorney reaction on things that I feel that I need to discuss, because I don't think that there's anybody who is a lawyer who's really standing up for Lane and his family. And so I just want you to understand that when someone gets thrown in jail, especially in a case like this with a statute that I think is ridiculous, usually it's the prosecutor trying to force a plea bargain. So they can say, see, look, all along he was guilty, and we knew it, and we won, right? And that's why they want to jail people. And the fact that he was denied a law library this whole time, I believe it's prejudiced his case. I believe what he said is true about advisory counsel. I believe if he had advisory counsel, that all emotions and pleading should have gone to him, and then he could have gone to his lawyer for advisement. And instead, the exact opposite occurred, based upon his statements in court. And I believe Lane. And I think that he's getting railroaded. Hi, Tiffany. So, you guys don't normally see me come live in the daytime. I've taken some time off from my regular day work so I could catch up and help with my son and with my family. And also, I have a heavy heart when I see what's happening with Lane. I feel like somebody has to stand up and talk about it. And I know a lot of you guys hate lawyers. Oh, you remember the bar, the British Accreditation Registry, which is total bullshit. But not everybody becomes a lawyer because they're trying to get rich and make money. Some people have suffered PTSD as a result of this justice system, and it's motivated them to become lawyers so they can try to change the system from within. And I'll let you guess which one I am. And yeah, Christopher, it really bothers me big time, dude. And hopefully you people who know me and have gotten to know me over the last couple of years, you saw that I went and supported Chile de Castro when everybody else was trying to throw him under the bus, and would meet with him in jail. And I never charged a dime, never asked for any money, rejected money specifically from him for the work that I put in, because it wasn't work to me. It was my civic duty to try and make people understand that there's grave injustice with a lot of government employees, and that if we don't hang together, we will surely hang separately, in the words of Benjamin Franklin. And so, to all the citizens of Arizona, my heart goes out to you that you've been Californianized, and I'm sorry about that. But you still have a chance with recall elections. And, hopefully now that the border is sealed up, the drug cartels will have less influence over your politicians, and you might have better opportunities at replacing your government with someone who's more pro-Constitution and Bill of Rights. And I'm a natural law advocate. I believe in creating parallel systems, homesteading and homeschooling, getting your kids off of the crack of the leftists and the Marxist state that control our education system and have been churning out judges and lawyers, unfortunately. And there are other alternative methods to becoming a lawyer, where you can do law study and you can still do regular jobs and be amongst the people you serve, the people that you serve in that office of public trust that you hold as a lawyer, which is a great honor. It's a great honor to be able to represent people and to try to save them from what I believe is an overreaching justice system in many ways. And so that's why I'm doing this show today very quickly. Hey, good seeing you, Tiffany. Thank you for all the compliments. And thank you, Chevy, for the donation the other day. That really meant a lot to my wife. As you guys know, because I'm not working as much and trying to build out this channel to help people, I'm not exactly rolling in the dough like I used to. So, but sometimes you're called to try to help people. And my dad said before he passed away, all of his life, basically to me, that if you do a good job, the money will follow and you'll always have opportunity. So just keep in mind, guys, that if you get in a car accident or a motorcycle accident in California or Texas, that I've got one of the largest motorcycle accident settlements in the history of the United States, over $10 million. I've recovered over $300 million through my law firm for injured victims. I've assisted people with habeas corpus, writs of coram nobis, and I have a background in appellate law. I was a judicial extern for the California Court of Appeal. I think I'm the only judicial extern for the California Court of Appeal who became a lawyer with no undergrad or law degree, and then later earned a Juris Doctorate at night after I was already a practicing attorney, so I could shut up all the statists who think that you have to have a government education in order to be taken seriously. And I can unequivocally tell you that I believe that law school was a complete waste of time, and that I believe that it was that all the people, with the exception of myself, were far left and don't support the Constitution and the Bill of Rights, at least the people that I went to law school with. I can remember a couple of them that I don't have relationships anymore who were veterans who think like me. But other than that, they were pretty much just lefties, and whatever the government said is what they would go along with. And that was disconcerting to me. And I want to make a difference. And so that's why I'm here today. Oh my gosh, Robert, thank you so much Robert just gifted a membership. That means a lot to me, brother. I'm hoping that, I'll see Mr. Gold or This Is a Public Service or a Reluctant Prophet pop in as well, because I don't know everything about what's happened with the case since I've been absent. And as you guys know, I've been, having my daughter help me post shorts and doing stuff like that are unrelated to Lane's case. But that's just because I'm trying to draw people in, trying to get the younger crowd, trying to get a different audience so I can expose them to natural law and natural rights instead of just having our one little clique of patriots. I'm trying to bring other people into our patriotic movement. And so you don't expect me to always cover Lane's show. I like to cover the DEI didn't earn it and all of this nonsense that's being forced on us by the radical lefties. I believe in a merit-based society. I believe that we need to judge people not based upon the color of their skin or if they're balling someone of the same sex, but based upon the content of their character. And so that's what you're going to get with Team MPE. What's going on, Kuna Parker? And Robert, I ended up going to University of West Los Angeles School of Law. And when I graduated in the ceremony, I was the only law student that was graduated as Michael Eline Esquire, because I was already a practicing lawyer when I got my JD. So I did it a little bit different than most people. I think at the time I was one of between 60 and 80 people in the history of the state of California to have had the honor to have become a lawyer with no undergrad or law degree. And my claim to fame, what I'm most proud of, is being a United States Marine and taking an oath to uphold, protect, and defend the Constitution of the United States. And that oath is still very valuable to me. And I really dislike the DEI hires and the prosecutors, and as well as the public defenders that have been hoisted upon us in a lot of the judicial districts. And I believe that if you're going to be a judge or a lawyer, that you should first have a regular job working with we the people and not spending your life in a law school or in far left woke college campuses. So you can see what it's like to get calluses on your hands and work hard. You should know how to disassemble a weapon and reassemble it and clean it and be able to protect and defend your family. And the Second Amendment should be just as important to you as the First. And most lawyers that I meet are anti-Second Amendment, anti-self-defense, to the point they sound like Canadians, where they'd rather see their wife and children get brutalized than come to their aid with a weapon. It's just the weirdest. It's almost like a cult. It's like a death cult of just weirdness. And so give me a bunch of ones if you agree. It's like a death cult that a man would stand idly by and advocate to not be able to defend his wife and children, especially when Sleepy Joe flooded our country with over 20 million illegal aliens, many of them violent prisoners who were released from prisons that are now immediately putting them on welfare and putting them into blue states for the purpose of using the U.S. Census to, by most estimates, for the Democrat Party to pick up at least 13 additional seats just using the census without them even having to vote. And we know that that's what he was trying to do, that his party was trying to do. They were trying to use illegals, and they still may be able to pull it off. If we don't get these illegals out of the state by the next census, the Democrats will pick up about 10 to 12 new seats, which means bye-bye Second Amendment and a lot of the other rights that we have in this country. So hopefully we'll be able, it'll be just like Canada. That's right, Tiffany. So let's get into the first video, and it's really not a video, it's more of an audio. But what I'm doing is I'm going to be here, I'll show you, to try to make this as expeditious as possible. What I'm doing is and look, I know I'm in vertical, I apologize, but this is how I get the younger crowd, and most of my audience uses handhelds. So I try to cater to my majority audience. And so this looks better on handhelds. So what we're going to do is hey, Clayton, good seeing you, man. Oh, look, so Tiffany says, I just found a Canada penny yesterday. Sorry, Michael, irrelevant, Your Honor. Well, that is pretty funny. Anyways, so let me just really quickly, I'm going to get into, first video is going to be Reluctant Prophet. And this is Lane Myers firing the attorney who did that motion for him. And if anybody, hey, good seeing you. What's the matter, you? I'm glad you showed up, bro. What's the matter, you is like he's like he's like my archangel that sits on my shoulder and whispers in my ear not to be biased. So I love having him here. Now, the next thing is the other thing that I wanted to ask is if people could please paste the donations link for Lane Meyer's charity, his charitable donations to help him and his family while he's suffering imprisonment so that they can be able to support themselves. Remember that when you're locked up, it families break up when you get locked up, and I believe that's the government's primary goal. The prosecutor's primary goal is to try and force a plea out of you, and that's why they keep you incarcerated. And I don't think there was any logical reason to keep Lane incarcerated other than to prevent him from being able to defend himself, because he keeps winning in court. His substantive arguments are solid. Yeah, I don't like the way he acts in court. I think it hurts him, but that's who he is. And so again, that's up to Lane and his creator to figure that out. But right now, let's get into listening to what happened, and give me a bunch of ones. And I put the links to each of these channels. One of them is This Is a Public Service. The other one is Reluctant Prophet. I encourage all of my viewers to please like and subscribe to their channels and follow what's going on with Lane, because I don't know if I can cover it on Friday because I'm in so much pain from my sciatica. I'm literally dragging my left leg around everywhere I go. And it's very difficult for me just to get my son to judo practice. So this is something, I'm at a standing desk right now, and we're going to cover this stuff. Good seeing you, Kinetic Customs. And make sure to like and subscribe, you guys, as well. So anybody who can paste his link, yeah, please do that. And send it to me, and I'll drop it into the description. Look, guys, please, I love it that you guys buy memberships, you support my channel. And before we start, just really quickly, if you want to learn about how to become a lawyer with no law degree or undergrad, you can pick up a copy of my book. It's an ebook, not this book. It'll be an ebook for $19.99 by just going to my YouTube description link. So go to my main YouTube page, Michael Eline, and click on the description and drop it down. And then you can go to, it has a PayPal link, and you can pick up a copy of this book for basically $20 if you want to learn about my journey to how I became a lawyer with no law degree or undergrad, and how you can do it too, and how I became much more successful than anyone I went to law school with. Because of my background in sales, marketing, and being a blue collar man, being a Marine, I'm able to relate to my clients, and I know what they're going through. I've had my run-ins with law enforcement, and I know how unjust the system can be. And so because of that, it's made me, in my mind, a superior attorney. And because I have externed for the Court of Appeal and ultimately bought a home right next door to the justice that I externed under, right on the ocean in Redondo Beach, I was able to learn civility and learn how judges think and understand proper civility and decorum in court so I could win. So everything that I did and learned was with, like being a Marine, training to be able to win so I can help clients like you. And so I encourage all of you, even if you don't want to become a lawyer, to read my book and what I did and learn about basic civility, because sugar will always get you more than salt. And there's very few people who are able to win when they talk over people and cut them off mid-sentence. So that's the only thing that I could say. Stephen, I was only in for about maybe 9.5 months, and then I was sent home awaiting orders. I blew my knee out. I'm a 70% disabled Marine veteran. I was medicaled out. I was injured at MCT, and then I went through school, SOI. When I went in, I was the first or second series in 1989 to go through MCT as well as SOI as an 0311 designee. And they stopped doing that. Now they put 0311 designees through SOI and non-03s into MCT. But when I did it, I had to do both. And so I injured my knee very bad at MCT and ended up going through SOI on crutches, and then was boarded out medically from there. But it's the proudest moment for me was earning my Eagle Globe and Anchor, and all my friends are Marines. My father was a Marine before me, and I have a nonprofit, a military veterans nonprofit. My father died from Agent Orange poisoning from Vietnam. He was an 0848, and he was an artillery guy, cannon cocker. And he was my greatest gift in this life. He taught me everything that I needed to know about tenacity and self-discipline to thrive and survive in uncertain times, and always taught me that your wife and kids come first. So that's what that's all about. And I do have an email. You can go to circleoflegaltrust@yahoo.com. And I do believe that God is real, Kane. Kane says God is real, and I believe that. Kane Fire Fist. That's cool. I do believe that God is real, and I believe that where the Declaration of Independence says that all of our rights come from our Creator, that's real. That all of our founding fathers believed in John Locke and natural law, and that is what our country was based on, is natural law. And unfortunately, the far left believes in the great Leviathan. They believe in an all-powerful, centralized, controlling government. And I see Arizona becoming like that, and it makes me really sad to see Arizona go the way of California. It's really sad to see all these commies move from California to Arizona, especially lawyers, and try to turn it into a garbage pail like California. I'll never understand that. They'll literally flee what they built because they burned their whole city down, their whole country, their whole state down, and they want to go and do the same thing. They're like the Borg. It's like a death cult. Give me a bunch of ones if you agree. All right. So yeah, designee. That's right. That's funny, Wassa. So let's get into the video now. And I'm already running out of time, but I have to take my son to get him a new gi. He's grown so tall that his sleeves are too far back, and he's got a competition coming up in June, and he's got to have a proper sleeves, because in judo it's leverage and throwing, and so it's unfair to make his uki try to reach high up to grab his gi. So I was going to get him a gi and get some mats and some new uki bands, and I'm going to try to go over some newaza moves with him as well tonight. So I'm going to try to make this as quick as I can to try to get through this. But I'm really grateful that you guys all showed up to join me in the middle of the day. I wasn't expecting really anyone to show up. But yeah, circleoflegaltrust@yahoo.com, Brandon. And that other person who talked about the blue, whatever it's called, I'd like to know more about that. I mean, anything at all that can help reduce the swelling. I have a crushed sciatic nerve at my L5. And it's primarily because of my injury in the Marine Corps, because I walk with an irregular gait. So over time, it's crushed the disc. So it's pretty painful, but nothing like the pain I'm sure that Lane and his family are going through. So I'm going to do this today and try to get through it as quick as I can. So let's go ahead and start. And guys, again, give me a bunch of ones for Reluctant Prophet. And this is a public service for them, just unrelentingly helping Lane and getting the word out and keeping this story alive. Really, really important. I mean, if you really know the whole story, who knows, maybe Lane made a few mistakes, but they certainly didn't rise to the level of felonies. And the statute, in my opinion, is clearly unenforceable had it been a case in California or Texas. I mean, even in a commie state like California, I don't think that statute would pass judicial muster. Let's keep going.
It's a motion to withdraw counsel. And then we need to talk about setting a trial date in the older case. Hold on. Parties appearances, we'll start with the state.
Rachel Stiles for the state, and Your Honor, the victim is present.
Okay. Mr. Parvin?
William Parr, we have Mr. Myers on the one case.
Okay.
I think it's 1-5. Okay.
Yeah, it's 1454. Okay. Mr. Myers, your appearance?
Yeah, I'm here. William Myers.
All right. So a couple things. As you all recall, I've previously ordered in both CRs that there be no cameras or recording. That includes any personal recording devices. It's not allowed. I am live streaming today's event. So
and why is that? I mean, why can't you live stream? I mean, it just doesn't make any sense, honestly. I mean, how is that hurting anybody by live streaming? If the court's already live streaming, why is it a problem for a party to live stream? Especially when you already have a Arizona Supreme Court rule that says you can audio record. It just doesn't make any sense to me. It sounds to me like judicial overreach that was spurred on by a prosecutor who has a bone to pick with people who want to exercise their First Amendment rights. And I believe that even though the court is a limited forum, you should still be able to audio record. Like all courts are courts of record. To me, it makes sense that you should be able to record. Give me a bunch of ones if you agree. I just think that is a wrongly decided ruling had it been in California or Texas. What do you guys think? Put it in the comments if you disagree. I'd like to know what you guys think. All right, let's go.
people, members of the public, obviously have the right to be able to hear what's going on. All right. The first thing I want to address is in the new case, 2025-1454, Mr. Parvin's motion to withdraw as counsel. So, Mr. Parvin, I take it you've asked to withdraw, and I'll ask Mr. Myers if that's what he wants. But anything to add from your perspective?
Just that Mr. Myers made it very clear, and that's why I emailed your clerk right away promptly. Do not rule on any of my motions. Mr. Myers wants to.
No, what's the matter? You just made an interesting comment that maybe the reason they don't want people live streaming is because people who are followers on YouTube are less likely to get pinged, right? So that's why I got to tell you guys, make sure to always like and subscribe to This Is a Public Service and Reluctant Prophet, because they're covering this stuff. So make sure to do that, guys. It's a big deal. I mean, if you really care about your rights, the least among us are the ones that you need to be concerned about most. And right now, Lane is the least among us in the eyes of, I believe, in the eyes of the government. And I believe they're out to get him, and they're going to find a way to get him no matter what. So just listen, and you'll understand more about what he's trying to do. But Lane is sick and tired of not being able to get copies of motions, not being able to have access to the law library as he was promised. And it just has the appearance of impropriety, guys. I think it's really unfair and unjust what's happening to Lane, looking at it from someone who's not just a lawyer, but someone who's also had to face the barrel of an unjust system.
Do them in the way that he sees fit. So please, I appreciate you not ruling on anything I have so far pending.
And that's a good reminder that I had taken an advisement of the motion to revisit the no bond hold. And so I'll note for the record that has been withdrawn by defendant, and the court will not rule on that.
For reasons that Mr. Myers wants to refile it himself.
Right. Yeah, it's without prejudice. Okay, so Mr. Myers, do you want to represent yourself in?
Just so you guys know, without prejudice means that it's something is denied without prejudicing you of your right to refile it again. So, for example, you file a lawsuit against someone, the court dismisses it because of a procedural error. Without prejudice, as a matter of right, you can refile it. So you're basically saying, without prejudicing you from bringing that same matter or motion again. Give me a bunch of ones if you understand. If you have further questions, ask me. If someone says with prejudice, that means you're probably going to have to go up on a writ or an appeal, because that means your right now has been extinguished.
The new case 1454.
Yes, I do.
Okay, so what I'll do is I'll ask you the same questions I did in the earlier case. Okay.
Yeah, can I say something before this starts?
Sure.
This hearing was supposed to, well, not supposed to be, but we had tried to get it last Thursday because I'm putting a rule of 10 on you at the end of this hearing. Well, not supposed to.
Okay, so I've done the research really quick. So a Rule 10, he's basically, so in California, we would call it like a 170.1, a challenge for cause. You can only do a peremptory challenge, a 170.6 in California, one time as a matter of right. So, and it has to be done before the judge engages. And what that means is you have the right to basically fire your judge and get a new one appointed. And so that's what this means in Arizona. It's a Rule 10. Basically, he's saying, I want you off this bench because I think that you're prejudiced against me. And I want you out of here. I want to get a new judge. So just so you guys know, give me a bunch of ones if you know what that means now. Rule 10 means Lane's trying to get a new judge.
What's a Rule 10?
Rule 10.1, change the judge for cause.
Okay.
Yeah, so.
Well, you want to do that now and have Mr. Parvin represent you?
I'm not allowed to do that before the hearing or during the hearing. That's why I'm saying this is like being in jail. It's like kind of like technically, we got to get to the technical nuances here. So, I wanted him to do this last, because I had 10 days from the last hearing.
Hopefully you guys can hear it.
I wanted to have this hearing last Thursday, but the state pulled the victim card. So then.
Well, hold on, Mr. Meyer. So when you want to have a hearing in court, the Victims Bill of Rights requires me to give certain notice. Okay, and that's just a rule. It's not something that it is what it is. We all have to live with it. And I'll tell you, there's certain circumstances where we have a court hearing and we'd like to come back a day or two later to fix something, but I can't. So we always have to set it 5 days out.
So because then I don't have to go around his schedule either.
Okay.
You need to go to the microphone.
Oh, sorry.
Yeah. So I'm just telling you, Mr. Meyer, It has nothing to do with your case particularly. It's just a rule that I have to follow.
I see your perspective, but I know that they did that to just buy some waste time because they
Well,
can
no.
read they can read my text messages and listen to my phone because they
Well,
can
no.
read they can read my text messages and listen to my phone call where I said I'm putting a rule of 10 on you on Friday. So they tried to drag it out to get it closer to the 10 days to make sure that I'm, but
Oh,
we'll get to that.
Okay, Mr. Myers, let me be clear. When you want to set a hearing, the Victims' Bill of Rights requires us to provide, not us, the state to provide notice to victims. That's just a rule of court that I have to follow. And so,
every
it is
hearing,
what it is.
every hearing,
Okay.
even the media hearings and all that, the media request hearing and all that,
Yeah, we always give notice.
but they didn't show up.
It doesn't make any difference. That's not the way.
Okay.
Don't
So you're
argue
saying
with
they
me.
have to give notice, but they don't
Yeah.
have to be here.
Correct.
Okay.
Yeah, that's the rule. And that's just a rule of court.
I thought the ones they didn't show up at, they didn't have notice.
No, they get notice.
Chose not to.
They don't have, there's no requirement for them to be here. The state has to give them notice. Okay.
That was
Okay,
my misunderstanding of the
all right.
situation.
All right. So, Mr. Myers, what I want to do then, if you've addressed that issue, is go over your, to make sure that you understand what you're doing by
Like the
waiving.
Feretta hearing, that's what we're here for. The Feretta.
Exactly.
Right.
The
That's
same,
how
I'm going to ask you the exact same question.
I want to do the Feretta hearing and then adjourn.
Well, all right.
You talked about.
Okay, so the Feretta hearing, just so you guys know, and by the way, I'm opening up the transcript of the video, so hopefully you guys are reading along with me. But the Feretta hearing would be the equivalent of a Marsden motion in California, where we're just trying to fire our attorney, and so that's what that is about. I just want you guys to know what's going on. So the first thing that he wants to do is fire his attorney. Now, I have not heard this whole video, but I do know that there was a pending motion. So if somebody can help me out in the comments, there was a pending motion to constitutionally challenge the actual definition of harassment and whatnot, the harassment statute, to basically get Lane released because of the vagueness, the improper application, and as applied principles. And I don't know if that's going to be heard in this case, but if somebody can tell me what the result was, that would be very, very helpful. So let me just keep
Preach on all that. Nope, because a new judge is going to set the trial date.
Okay. All right. Well, we'll talk about that. The first thing I'm going to ask you, and again, these are questions I've asked before, but we do it each case, okay?
Yep.
Do you read and understand English?
Yes, sir.
What's the highest grade you completed in school?
College degree.
All right. Have you ever been diagnosed with a serious mental illness?
Definitely not. Here, let me.
Mr. Parvin, do you have any Rule 11 concerns about the defendant?
Hold on, I'm trying to find it again. There we go.
Have you considered filing a Rule 11?
I will say the only time that I was tempted, I had a conversation with Mr. Myers and told him he needs to calm down and proceed well in court. And as the court remembers, he did excellent the next time and was much more behaved. So the answer is based on that conversation, how Mr. Myers acted the next time in court, they did so much better. The answer would be no, if that makes sense.
Yeah, thank you.
Court decorum doesn't mean incompetence.
That's true. Okay, so strike that. I guess Rule 11. Hold on a minute.
Oh, we got to fix one thing. Hold on just a minute.
So I guess the Rule 11 from this perspective is that it looks like, have you considered making a statement to the court that your client is incompetent to stand to be a self-represent? So, and again, I'm not an Arizona attorney, guys, so don't hold this against me for not knowing all the ins and out of their system. Hold on, let's get back. So this was at 13:30. All right. Hopefully you guys are tracking this for you.
We're just turning on the conference in case anyone calls in.
The what?
The conference. Okay. All right.
There's
we're
nobody typing today?
Hold on. And we're streaming, correct? Yeah. What was your question, Mr. Myers? We don't have. So what happens if we don't have a court reporter? It gets recorded, and they can create a transcript from that. That's
Yeah,
how
and
it
then
works.
when you post it on YouTube, you get charged with a felony.
Well, I'm not going to comment on that. All right. Mr. Parvin, you wanted to raise something else?
Yeah, I want to reiterate that the reason my answer is no is Mr. Myers has already been in court and basically proved he was competent in a prior proceeding. This has come up before. I have not taken the issue lightly. I have thought about it, but I discussed it with Mr. Myers. After that conversation, when I warned Mr. Myers that you can't act this way in court, the fact that it's so much better the next time alleviated my concerns. And I'll say that for the record that I did think about the Rule 11 possibility, but basically that makes sense.
Sure, absolutely. So noted.
Do I get to say anything about the Rule 11?
Sure. What would you tell me?
Ask Matt Walker what happened when he tried that.
I don't know what that means.
He tried to put a 47-page Rule 11 and it got laughed out of court. I'm not incompetent in any way, shape, or form. There's some
Okay.
people in this room that are, though.
Okay. So you have the right to counsel at all stages of the proceedings, including appeal. And if you cannot afford counsel, you have the right to a court-appointed lawyer at little or no cost to you. Do you understand that?
Yes, sir.
If I allow you to waive your right to an attorney, do you understand that you can change your mind and request to have an attorney represent you?
Yes, sir.
I'm going to go over the risk of self-representation. It can be difficult for a person who is not trained as a lawyer to identify the charges and to determine the possible sentence. Sentencing law is fairly complicated itself. When you represent yourself, you're held to the same standard as lawyers. You're not trained in the law to the same extent as a member of the bar. You may not be as familiar with court rules. It may be harder for you to pick a jury, make opening and closing statements, cross-examine the state's witnesses, and examine your own witnesses. It may be hard for you to make arguments to the court. It may be difficult for you to prepare your case while in custody, hard to subpoena witnesses, review disclosure, and interview witnesses. It may be harder for you to file papers with the court. You may have less credibility before the jury than a lawyer would have. The service of an attorney can be of great value in determining if the charges against you are sufficient as a matter of law, whether the procedures used in investigating the charges and obtaining evidence against you were lawful, including the lawfulness of any search, seizure, or police questioning. If any act you may have committed actually amounts to a crime for which you are charged, if you have any valid defense of the charges, and if found guilty, whether you should be placed on probation, required to pay a fine, or sentenced to term of incarceration, and whether appellate review could be justified. Do you understand all those concerns?
Sir, is this the rule? Is this all Rule 6.1 stuff?
It's all the rule on self-representation.
Because I never signed nothing last time. That's what I was wondering.
What's that?
Because it said I never signed nothing last time.
Yeah,
So-
you did.
Oh, I did?
Yeah.
Saying that I was going to represent myself?
Yeah.
Okay.
Yeah. Do we have a form for that? Okay. I'm going to have to take a break because I didn't print that form off.
Okay,
before we're done.
that's why I was wondering, don't I have to sign something too?
Yeah, you do have to sign something. And do you understand that if you're found guilty of the offense as charged, I could sentence
Okay, so
you to a term
There
of
you go.
incarceration? And understand those risks of self-representation. You still want to waive your right to an attorney.
I waived this knowingly and intelligently.
Okay. Has anyone promised you anything in order to get you to waive your right to an attorney?
No.
Has anyone forced you or threatened you in any way to get you to waive your right to an attorney and represent yourself?
No.
Have you had the opportunity to discuss your decision to waive your right to attorney with Mr. Parvin?
Yeah. I'm the
All right.
one making this happen.
All right. The court finds, after discussing the matter with the defendant and observed the defendant's demeanor, the defendant has knowingly, intelligently, and voluntarily waived his right to an attorney. The court will allow Mr. Myers to represent himself. We are going to take a quick break to
Thank
get that waiver form for Mr.
there we go,
Myers
right here. There we go.
to sign.
Sorry,
Now,
the transcript's
with
kind of
that, the next question is, Mr. Myers, I'm going to still appoint Mr. Parvin to be your
You have to do somebody else.
advisor. What?
It's got to be somebody else. We have an irreparable. We
irreconcilable differences.
We can't.
Okay.
Yes, Your Honor.
Yeah.
I think both of us are strong.
Yeah.
I think both of us are strong-willed and want to file motions, and we have different strategies and ways of doing those motions. And for those personalities class, we have two strong-willed people trying to do motion they build best. I believe Mr. Myers needs somebody that just a different attorney for advice because we're just clashing in that regard. I think we both have the same goal, but we have very different ways of getting it.
Okay. So, Mr. Myers, Mr. Parvin is well versed in both of your cases. He's done a lot of work on these cases. If I appoint you a new attorney, that attorney might have to start from scratch. Even if we set a trial date, that attorney may want additional time to come up to speed which could cause a delay in your case going to trial. Do you understand
Are
that?
you requiring me to have advisory? I know you have the
Yes,
authority to do
I'm
that.
going to require you to, and there's a couple reasons for that. For one thing, when you're in custody during trial, it makes it much harder to do things if you don't have an advisory lawyer who can help you out do things.
So if I get released in the next couple of weeks, I can fire them too.
Well, we'd have to have a hearing on that.
We're gonna not with you though.
Well, yeah, whatever.
Yeah,
But
no,
what
it's not whatever, but I know what you mean.
what I'm saying is, Mr. Myers, that it's helpful.
What if they're
Even
what if they're
the lawyer-
incompetent?
What's that?
What if they're incompetent and they do more harm than good?
Well, they don't have to do anything. You're doing everything, but they're just there to assist.
But that's
you.
not true.
I'm not. I know you. I know. I've read. I know you have. I know you can make. You have the power to say you're. Even if you don't want advisory counsel, I'm going to make you.
Well, so the advisory.
But I think
lawyer,
that we should have that person and I should have a working relationship.
Yeah,
well,
agreed.
so
He's right.
that lawyer just is there for your assistance.
No.
When I need assistance, right?
Yes,
Right.
you speak to me and to the
Right.
jury.
And
But I'm just telling you, a person in custody, especially, it's very helpful to have a lawyer to do things such as arrange witness interviews.
I don't disagree. I don't
So,
disagree.
They're
I'm not-
basically your helper.
Yep. Yeah, I get it. I get it.
All
Now,
right.
now here's now, because I already figured you were going to do that because
Yep.
of what I'm in custody.
Listen
Once
to this.
I'm out of custody here in a few weeks, we can readdress that, but it'll be a different judge. And so the thing is that the problem, or I don't want to necessarily say problem, but up to this point, Rachel has been manipulating the situation to where Ms. Stiles has been manipulating the situation because that person is there when I want to go to them. That person is not the intermediary where they send all the disclosure to them and then it's their burden to get it on me, and I don't get anything until my advisory council brings it to me. So to me, if we're doing like a little chain of thing here, it goes from the state to me, and then if I need advice, I go to my advisory council.
That's right.
But Ms. Stiles is manipulating the situation, forcing everything down the advisory council's throat, and then saying, well, you two work it out, and then coming here to court and saying, well, he's got advisory council. It's not my responsibility to do anything to get it to him because I gave it to his advisory council. And that's got to stop today. Okay. And so quick, guys, this is another reason I'm.
And here's the thing. So where were we at? All right. Let me just share something with you guys. I mean, what Lane said was prophetic. He's absolutely right. He nailed it. He's not getting any of his motions or pleadings sent to the jail. I'm just telling you, as a practicing attorney, for me to go and visit my client in jail, it is a nightmare. All right. I got to run my shoes through a freaking scanner. I'm empty out I got to basically leave my law practice, leave all my other cases, drive to the prison, go through at least a 20 to 30 minute check-in process to be able to go and see my client. I've got to call in advance to try to arrange time to see him, to make sure that they'll pull him out, right, of the general pop or wherever he is. So basically, what he's saying is 100% true. He's being railroaded, and he's got no way to get any of this stuff. Now, if the prosecutor was behaving fairly, in my estimation, at least in California, she would have arranged something with the warden or the director of the correctional officers to where a process server would bring that paperwork to the jail and it would immediately get into Lane's hands. After all, he was promised access to the law library. He was promised advisory counsel, and that means someone who advises him, not someone who gets served and filed all of his papers that he doesn't have access to until 3 or 4 days later, whenever the lawyer is able to escape his other cases and go to the jail. I mean, Lane just absolutely, what he's saying is so true. And that's why and one of the reasons why I've officially bestowed the title upon him is Braveheart, because a lesser man would have caved and pled out. And my opinion is the main reason that Lane wanted to fire this attorney is because, like most lawyers, he wants to plea the case out. That 99% of lawyers just want to plead. They want to waive time and plea the case out. Another reason why I don't do a lot of criminal defense, because I know the amount of time and effort to actually win a case where it's going by the law, by the Constitution, would basically bankrupt my law practice. That is the way the system is. If you guys really want to change the system, don't blame me and don't blame lawyers. Start electing people and put legislators in power who will actually change the law so that we can get a fair shake Okay. I'm doing everything that I can. I mean, I'm not making any money off of this show. I'm trying to get the word out because I want you to understand that there are still a few patriots out there who will stand up for American citizens who are being denied their rights, not people who snuck across the border and invaded our country, but American citizens. They're entitled to the unalienable rights that our founding fathers bestowed upon them. And we need to stand up for these people. So let's keep going.
Getting rid of, having it because everything needs to come through me. The advisory council shouldn't be aware of anything that's happening in my case unless I go to them and say, hey, what do you think about this? Not they get everything and they filter it down to me. And that's what's been happening. And that's why I'm sitting here a month and a half in, and I still haven't got this stuff. But then Ms. Stiles will say, well, I gave it to Parvin. Well, then that's pitting me and Parvin, and all they're doing is using him as a pawn in between us. And so, if I'm if I'm the attorney, that means the first person that should get anything is me. And then I can say, hey, advisory council, what do you think about this? What do you think about that? Have you read this? Can you look at this? But that's how it's happening. So I figured you would, because of the custody thing. It makes sense. I'm not stupid. I'm not incompetent. So I understand, it's hard to do a subpoena or interview and all this. Okay, cool. We'll get, but it's also needs to be used properly. It needs to be the chain of command, however you want to, the chain of custody, however you want to do that. It shouldn't be that, they give it to him and then once a week he comes and visits me and gives me the stuff that they should have gave me instead of giving it to him. And so that's where this whole thing is being misused. And I realized he was on one case and he was on the other, but in the first case, they were still sending everything to him and then relying on him to get it to me.
That's right.
Yeah.
What's
that?
I just want to approach on.
Oh, come on, counsel. Well, actually, let's.
Now he's
Yeah, I don't.
Okay, so let me explain what that means. So typically, when a lawyer says, I want to approach, that means he wants to have a confidential conversation with the judge at sidebar. And so since it's not allowed to be ex parte, what will happen is the prosecutor, the lead prosecuting attorney, as well as Lane's attorney would approach. But in this case, Lane has this lawyer's advisory council, so Lane should also be allowed to approach. Does that make sense? Hopefully you guys are understanding a little bit of, I'm trying to teach you guys what I know, because not everybody understands this stuff. I know a lot of you guys do, but a lot of you don't. So I'm trying to kind of walk you through what's going on. By the way, good seeing you, Brett, man. Hey, Brett's one of my big homies. Thank you, Brett, for being an American patriot and joining me this afternoon. And thank you, Ramu Broadman and Lynn Davidson. Oh, man, all my homies from Team DLZ. What's the matter, you, Lynn Davidson, Kinetic Customs, Gloria Ad? What the heck? I got the full Team DLZ crew. Go Team DLZ, right on. And F, how you doing, man? Good seeing you, F. All right, so let's keep on going. Hopefully you guys are enjoying it so far. Right, so we're at like 23. Okay, let me get back up.
Made aware for further conflict.
Yeah, and he's also representing somebody that's harassing my wife too. So he's got to go on all levels.
So Mr. Parvin is indicating that he has a conflict where he wouldn't be able to continue.
That's right.
Sounds like as advisory counsel.
Yes.
But he had a conflict the whole time.
Another person I represent.
Gotcha.
Who's harassing my wife?
All right. So I'm gonna hold on. I'm gonna release Mr. Parvin, and we will appoint.
You put Mark Resnick.
It's up to OCAC to make that. They have to decide that. So we'll have the next person on the list. I want to take a very quick. I just completely forgot about that Rule 8 form. So let me go get that, and then we'll have you sign that.
6.1 thing, the waiver.
This is the waiver.
Okay.
It's just a waiver of right to counsel. So let's go off the record for 5 minutes.
Thank you.
All right, so he comes back at 33:23. Let me see if we can fast forward it. Hope you guys are having a good time so far. I love having all my friends here. This looks like it's going to start right around.
Mr. Myers to sign.
Your Honor, we just had a situation come up that I need you to clear up again.
Let's finish this first, okay?
Okay. Oh, this 6.1 thing?
Yeah, that's the notice of waiver of right to counsel.
You signed this back part, right?
Yeah, you signed page 2.
I signed it.
Okay.
Hey, at OSWE.
And Mr. Myers, did you date it?
Oh, I'm sorry.
Can I put? You mind if I put the date on?
Go
Or
ahead, go ahead.
Would
No.
you rather do it?
It doesn't matter. No,
Okay.
it's fine.
So today is the 28th.
I signed one of those last time too.
You did, and
Okay.
yet for the other case.
I think it was right when I was leaving or something.
Okay. So what do you want to tell me?
So again, the very same thing that I just talked about prior about the advisory council just got brought up again because I had asked if I could, talk to Rachel for a second, and Rachel seems to think that she can only talk to me, Miss Stiles, excuse me, if advisory council is present. No, that's the point. The advisory council does not represent me. They're advisory council.
Okay. I'll make a rule on that. Ms. Stiles, what's your position on that?
So, Your Honor, my concern is that he is constantly claiming that I am misleading things, misrepresenting, doing all of these things for his protection to make sure that we have.
Well, I've got news for you. I've got news for you guys. Every lawyer does the same thing about their conversations with the prosecution as well. I think that Ms. Stiles is overreaching here, and it has the appearance that she is trying to deny him his ability to properly defend his case. To me, it looks like it's a personal battle between her and Lane. She probably doesn't like him because he wears a MAGA hat, and she's probably a radical leftist like most prosecutors and public defenders, in my humble opinion. Now, thank you, Robert Stubblefield. Cheers. Robert Stubblefield just donated $5 to Team MPE. And he says, cheers, Team DLZ. We came together. We'll be greater later, baby. I hope so, Robert. I'm so glad that Chile got justice and we were able to get his case reversed on appeal. But the thing is, guys, make sure to put Lane Meyer's donations link in the sidebar, in the comment bar. The thing is that the government will separate you from your family and they'll put pressure on you to enter into an unfair plea bargain agreement. And this is a standard. And a lot of prosecutors use cases like this to try and build their career so they can get into a higher office or become a judge. And damn the torpedoes. And I'm so grateful that when I worked for the prosecutor's office in Los Angeles, that I had a really good attorney. He was prior military as well. And he said that our job is to do justice, not just get convictions. And here, based upon my understanding of the facts of this case, as well as the law as applied to Lane, if this had been in California or Texas, Lane would not be incarcerated right now. And so obviously I'm not an Arizona attorney, so I can't really tell you what I would do if I was in Arizona. But if I was in Arizona federal court and I was pro hoc in, I definitely think that Lane should be out. He should not be incarcerated, especially when he was promised access to a law library and he was promised advisory counsel, and he's getting everything but those promises. The paperwork and pleadings are not being given to him. He's not being allowed the opportunity to use the law library, at least as far as I know until now. And that has severely prejudiced his case. And I believe that if he continues to fight and he doesn't cave and go into a plea bargain, that most certainly this case on a federal level, on a civil rights basis, will be reversed on appeal if he gets convicted. I think right now he could go up on a writ, probably a writ of prohibition, a writ of mandate, maybe even a habeas, and probably get some relief from a federal court. I really think the way that statute is written, that harassment statute, basically makes it open to interpretation. And if you get a leftist on the jury, he's going to lose. If you get somebody who supports the Constitution, he's going to win, unfortunately. So that's just my humble opinion. Let's keep on going, guys. So we're at 35-20.
Clear communications, it makes sense to me for advisory council to be present, as well as the fact that if advisory council needs to take over at any point, if he decides he doesn't want to represent himself, it's better if advisory council is familiar with everything that's happened. So what I would do is we could facilitate where we have a Teams meeting where all three of us would be present on it, but he would be speaking to me directly, but advisory council would be there listening and then could give him advice as he needs it.
No,
What's wrong with that?
Because the whole point is this is
I'm representing
I'm representing myself.
That's
If
right.
I want them to know something, I'll tell them. I don't need these people looking over my shoulder. I don't want their advice. You're forcing them. First of all, I respect your inherent authority to force me to have advisory counsel, but I'm making it very clear. I don't want these people, and I don't want them involved in my case in any way, shape, or form. In fact, I'm going to ignore them. Okay, I'm not going to say a single word to them. I don't even want them sitting next to me. And she's trying to make it seem like they got to be in every conversation. That defeats the whole purpose. No, I'm representing myself. You come to me directly. I'm not going to have to work around their schedule. That's the whole point. These hearings, I got all day. These people, we can only talk when
understand.
they're available. And no,
all right.
no.
right. Mr. Myers, I understand. I'm going to order Ms. Childs that you communicate with Mr. Myers directly. I agree with him if he's self-represented.
Absolutely. Amen. That's the best
Right
ruling I've heard all day.
Discuss that directly with you. So,
Your Honor, I just want to make clear that if he engages in abusive conduct,
Yeah.
I will end the meetings with him.
okay, you got
Yeah, and she gets to decide what abusive conduct is, right? I mean, it's absurd, right? It's absurd. I'm just blown away at the way she's behaving, honestly.
to be
So
professional.
yes.
So,
we got to get to that point, though, right? We got to actually get to a meeting before I can be
right,
professional.
I just told you that you can talk to her directly.
I know, I appreciate
You
it.
just
That's
have
all-
to-
I was just rebutting what, I just wanted to clarify or,
Okay.
He's right.
clear up her concern.
So the next thing I want to discuss,
Petty.
now that
Absolutely
Mr.
petty.
Myers represents himself in both matters,
Thank you.
it seems to me that the cases could be consolidated.
Absolutely.
And Ms. Stiles, are you going to file a motion to that effect?
Yes, Your Honor, I can.
Okay. Well, we could do it today if you
Yeah,
do. You want to? Do you want
Just do it. Do
to?
a
can we do it
sponte.
oral more?
Yeah.
I mean,
do a
the court's been
sponte.
asking her. I've been trying to do it. That's why I tried to do it last
Stipulate on
week.
the record.
Okay.
The concern, because the reason that when they become consolidated, is it all one case number?
No, it's still two case numbers.
Okay. Because I need to file this Rule 10.1 on both on the whole encompassing thing. So somehow we need to get them together. So I don't need to file two separate motions on everything.
So they'll be consolidated for purposes
Right.
of trial.
Right.
So
And motions.
motion.
Right,
Yeah. Well,
okay.
trial meaning that trial proceedings.
Thank you.
So, but they retain their original CR numbers because they're two different indictments.
So I'm gonna have to just write both on each motion. Or
Correct.
not two separate motions like I'm doing now.
Correct.
That's what I'm trying to
One,
avoid.
and that's what they do, right? It just has both CR numbers. So put both CR numbers on your motions.
Thank
Okay.
you.
So based on the stipulation of the parties, the court orders that two cases are consolidated
Good job, Lane.
for purposes of
proud of you,
trial
man.
and litigation, but they retain their same CR numbers as each one reflects its own
Thank you.
indictment. Next,
Good job, Lane.
we have a trial date in the new case 1454 that Judge McDonald put on the calendar. I believe it's July 21st, and I'm inclined to consolidate those both for trial on that date. And I checked. That's within speed trial as the first case.
Can
as
I bring
well.
up a concern with that?
Sure.
They're trying to call my wife. She won't be available. I need the case before July 4th. She's going international at that time.
I'm going to set it when I'm going to set. I can set it later. I can't set it faster.
I'm just sitting in jail though.
I had 300 cases.
Oh, I feel you. But okay, well, so let's pause there for a second, and I don't mean this in a threat.
And I'll tell you, most cases are older than yours, even with people in custody. So there's nothing that's special about your case that would jump.
I feel you. I feel you.
Well, I would say that if Lane has not waived time, then there is something special about his case. And that's why I have a problem with most lawyers is they immediately waive time. No, don't waive time, guys. Never waive time. Freaking stand on your rights. At least I'm not giving you legal advice, or I'm just telling you my family member, my friends who trust me. Why would you ever waive time? You have an unalienable right to a speedy trial. Why would you waive that right? There's just something unholy about that, guys. You have God-granted rights that come from your creator. Why would you waive them? It makes no sense. That's just my personal opinion. What do you guys think? Put it in the comments. Put it in the comments if you think different.
Are we still going to have the hearing next Monday? Because I
don't know that we had another hearing set.
Yeah, May 5th.
What was that for?
That was for you because you were going to do research
Oh, okay.
and all this, and we were going to set the trial. The concern I'm having, the reason I want to kind of pump the brakes a little bit today is because I wanted to have this Ferretta hearing consolidate the cases and adjourn, because I now, and I don't mean this in a threat. Please don't take this as I'm trying to push, in your, I'm just saying as a ripple effect of what I'm about to do, the case is going to get reassigned to a new judge, and then we can set that on their schedule. So then you might set a trial date, and then next week it's in front of a new judge, and that trial date don't work for that judge. Because, I'm going to put the rule 10.1 in when I get back to the jail, but I needed to be on both cases to do that and to have them consolidated. And then once you do that, you're going to have to reassign it. You're going to have to, the process. Right. But then, I feel it's going to get reassigned just because you're clearly breaking some laws.
We don't need the May 5th hearing right now, correct?
Correct.
Would you agree, Mr. Myers?
Yeah, that's what I was trying to figure out, is because wouldn't it be redundant because we withdrew the bail hearing?
Yes.
Because the bail hearing was supposed to be within 7 days of him filing. So you already went way past that. And in Dominguez and Metcalf, I read your thing. So, I'm already scared that you don't follow the rules of procedure as they're written.
Ouch.
And so that's why I think it's best that if I just put this rule 10.1 and we get this moved to a different judge for everybody involved. And then not just because of the hearing, but for multiple reasons, including you just denied 122 again. But so once it gets assigned to another judge might not have those days available. And then we got to go through the whole Rule 8, extenuating circumstances. I'm not waiving Rule 8. They're going to have to get permission from the Supreme Court to adjourn, to stop using Rule 8, all that. So I just feel like.
Well, how about if we set a hearing on May 12th to set the trial date? That's 2 weeks from now.
In the event that it doesn't get reassigned?
Yes. Well, I mean, it would still be on the calendar. If a new judge gets assigned, that judge could keep that 12th date or could
for the 12th date for the right, but not lock the trial in today. Use that as the next date to possibly set trial.
Exactly.
That's what I meant.
Oh, thank you. So I'm going to set May 12th as a status conference to set trial date in both CR matters, which will be one trial. I'm telling you that I'm inclined, if the presiding judge doesn't remove me from the case, to hold the
21st.
Have the 21st as a date. And if you say that you have a material witness who can't be there, it's
They
going to
do.
be later,
They do.
not earlier.
Right, they do. So the thing, okay, so
Hold on.
then,
No, I thought
my
I thought it
my
was
bad.
your witness.
No, they said they're calling my wife to testify against me.
So I want to clarify, it's not his wife. They're not actually legally married. And
Time out. No, you got to stop. What we call.
so
Hold on,
There-
hold on, Mr. Myers, just a minute.
No, I'm standing on business with this. They need to
Hold on.
stop telling me what I call my wife.
So hold on really quickly. So I'm not sure, but if Arizona recognizes common law marriage, then she is legally his wife. I don't know. Can somebody put in the comments as to whether or not this woman is his legal wife? I know many states, they have what's called common law marriages. So because having the state involved in giving you a license is not anything that our founders ever went along with. It was just a way for the state to get involved in our love life and be able to get involved and tax us and basically have more control over us. Give me a bunch of ones if you agree. So somebody, if you know, do the research, drop it in the sidebar. But if Arizona is a common law state, then she would be wrong. But if she's not his wife, then it is true that the wife is, or his significant other, unless they have some kind of a civil marriage that's like the gays have, before they made it legal for them to get married. If they have something like that, then privilege would apply. They call it marital privilege, where she would not be his significant other could not be called to testify against him. And so it looks like Miss Stiles is going to try to get his wife under penalty of perjury to come in and testify against him, and then hold her in contempt of court if she refuses, so she can also jail his wife. And I would say that is likely what is going to happen here. So just keep in mind, if you don't do what the government wants, they will find a way to destroy your life. And that's why we need to do recall elections and put people into positions of power who follow the Constitution and not just the rule of law, but the spirit of the law. Not power-seeking DEI appointees, but people who actually understand and want to follow the law as our founding fathers had set it up for us. Give me a bunch of ones if you agree.
Mr. Myers,
If we
hold on.
no, they don't. They keep putting this in motions and putting it in quotes and all this.
Hold on. hold on. Just let me talk. So
It's
hold on.
disrespectful.
No, what they're saying is there's a privilege between spouses.
We know what that is.
Okay. But you can only
We're
claim
not
that
exercising it.
hold on.
Nobody's exercising that. Nobody.
That's what she's mentioning.
No, but they're putting it in emotions too. Stop disparaging our relationship.
No one's disparaging it.
They put it in quotes like, "Oh, he claims it's his wife." What do you think? I'm secretly claiming my wife and she doesn't know it?
Hold on. It's only as to whether the privilege applies. That's what
Nobody brought that up.
Okay, that's why she's
They brought it up in motions.
All right, Mr. Myers.
His wife. They brought it up in a disclosure thing.
All right, I understand, Mr. Myers.
Wife, but they're not married. We can be in a relation. You don't have to be legally married so that that's to protect assets.
It's only to talk
Legal
about the
reasons.
privilege.
No, it's not. It's to be rude and
No,
disparaging.
they're not being rude. They're not.
Okay, well, I'm going to call her the fake victim then.
No, we're not going to do that. That's disrespectful too.
Well, I mean, she's not really a victim.
Mr. Myers.
It's like she's not really my wife, right?
Remember, I allow you to hold on. Hold on.
They're picking at this. They've been doing this over and over, though.
Mr. Myers, I allow you to represent yourself if you're respectful. Okay, that's a rule,
All right,
and I had the chance to pull that. Okay,
respect.
the only reason she mentioned that was a privilege, and we're not talking about that today. So, okay.
And just to clarify, that is the reason I'm bringing it up, because when in a legal proceeding, if you refer to somebody as a wife, that triggers certain legal things. And so that's why I'm clarifying that for the court.
Right.
And we will take care of that. So if she is going to be unavailable, we will file for a deposition if need be. We will take care of our things that we need prior to the trial date. So,
Okay.
so I'm not concerned.
I'm not setting the trial date today, but we're going to come back on the 12th.
Yeah,
and I'll set the trial date of the 21st of July. That's a good date for me, and it was already set, and it's within speedy trial.
gives enough time to, because the last hearing was, they were talking quantum physics and we should have been taking kindergarten math. But for some reason, all right, so he did bring up you extending the 12.9 in the 1454. I just want to make sure that got put on the record.
Did we do that last time?
I mean, we brought it up, but it kind of got swirled in with everything at the last second.
So we just got the transcript. At least I just got my copy today. So I imagine the court should be sending him his copy.
Hold on. What are you talking about? The transcript of the grand jury?
Yeah.
We've had that for 3 weeks.
The 1554 transcript?
Yeah, I've had that for 3 weeks. And I've been trying to extend the 12.9 since McDonald was hearing.
It was just slower to me. So I don't think we actually accomplished that the last hearing to extend it. I'm fine giving him another.
Because it is in the first, remember you did it in the first one?
All right, Mr. Myers, what's the date you want?
You extended it from 45 days to 60 in the first one. So if you could do the same thing to refile to remand, 12.9 remand.
I have no objection to that.
No, I realize that's getting close to. It's kind of like you're playing with both sides there. The trial is within so many, and if you do that, it's not that I'm going to take that long, because then that would interfere with the trial date and all that.
Right.
And so,
how about if I give you 45 days?
Fine. Yeah.
All right.
From today or what?
From today.
Yeah. Okay.
Yeah.
Yep.
So I'll grant, and this is in 2025-1454. Extend the deadline for remand.
It's holding his own,
What
man.
is the actual date on
It's
the
holding his
calendar?
own. I'm impressed.
Let's see.
I've never seen a pro per that is good as Lane at what he does. I mean,
Because when you file that, it stops time, right? But what does it do for a trial date that's already set?
It excludes it. Well,
Does
it
it-
depends on whether we can do. If it's granted, then it has to go back.
Well, no, I know what I'm saying, because like 45 days, so trials is July 20th, it's April 28th, so May, so we got 90.
So here's what's going on so there's a lot of procedural maneuvering, and since Lane is pro per, he's concerned, like, wait a minute, even though you guys screwed up and you're basically sitting on your hands waiting for me to make a mistake, by me saying I want more time, does that mean I'm waiving time for trial? And I think what the judge said is, by saying it excludes it, it sounds to me like he's saying you waived your right to a speedy trial. I'm a little concerned at this point. I'd like to know more about what's going on. I'm really hoping that somebody knows more about what's going on procedurally than me. Like, if somebody could reach out, I want to report on the facts. I don't want to make up stuff. I don't want to try and guess. I don't want to give you my best estimate. I just want to know what the facts are and wherever the facts lead us. Okay. So let's keep going. Let me get the screen back. All right. Give me 1 second to find myself here. So it's 4630.
20 days, okay, so 45 days. That would still give time to file the 20 days before trial and all that. I'm just trying to count backwards. So everything, if we have the July 21st trial date, I'm gonna have to have everything by like July 1st, basically end of June. Any motions that need to be 20 days out. So that'll give me all of June and all of May. Okay. Thank you.
It would be June 12th.
June 12th.
But remember, Mr. Myers, if the court grants your motion,
Well, we lost that, but
They will.
then that reindict you, then that's going to extend the trial date.
They committed. So I wanted to ask you this as a matter of course here. Do you get a copy of that? Because she's saying because I'm
Get a copy of what?
The grand jury. Because she's
No.
saying she just got it.
I don't get
I've
that.
had it, so I'm trying to figure out here. So you don't get a copy of it
No.
because you used it in the slap motion. How did you get a copy of it for that?
ooh.
You denied the slap motion. You referred to it about 12 times. You
Maybe I
referred.
did get it.
You referred to the
I
grand
think
jury transcript about
yeah,
12 times.
I think I asked for it.
Oh, you
Wow.
asked for it.
Yeah, typically it's not sent to me as a matter.
Asked for it.
Yeah, typically it's not sent to me as a
Damn.
matter of course.
Okay.
Damn,
But I
Lane.
wanted to review it because of the probable cause
Can
determination.
you do that again here?
What's
Ask
that?
for it because the detective committed perjury.
Well, you can file a motion on that.
All right, all right.
Yeah, you
I
got
just wasn't sure if you had that back there already.
okay.
Because the issue I'm bringing up is like attaching it as an exhibit, you
He's
know,
really good.
and then that's my only copy.
Okay.
Yep.
Were you-
Right.
Isn't there a way to photocopy things at the jail?
Not for Lane. Not for Lane. That was done on
So-
purpose.
When I've inquired with this at the jail, he has to put in a request for the librarian. The librarian can make copies.
It's
It's
ridiculous.
not true. She's lying. I don't
Oh.
want to say she's lying. I got the thing right here. We can do an evidentiary hearing on that. That they want to come testify because she said that she talked to a captain. They laughed in my face and said, "Have me come testify under oath that what she said is not true." What I can do is request forms, like subpoena forms.
God,
The
Lane.
only thing they can print me is forms. Like I could say, can I get some subpoena forms? And they're like standard forms, Arizona rule, whatever
Yeah.
form, you know, motion to quash a warrant form. They can print me forms that are, you know,
I
Arizona
understand.
rules forms.
So
They
let me-
can't copy anything. They can't print any case law. And when they read her thing, they literally laughed in my face
So-
and called it hearsay.
Mr. Myers, one advantage of having advisory counsel is to help you with stuff
Right. No, I
like
get
that.
it. That's
All right.
that's why I'm not disagreeing with you about it.
Okay. So we're going to come back in 2 weeks to set a trial date unless the presiding judge grants your motion to change.
So nothing
change-
about the.
So did you hear that? He just glossed over it. So basically, Lane's not going to be able to make photocopies. He's not going to be able to do jack shit. He's got to rely on his advisory counsel, who's going to basically have to shut his whole day down and go through the process of literally like trying to get a hold of his client, get a hold of the prison, go through the interrogation at the prison, you know, go through the search. Every single time his client wants to make a photocopy. I mean, talk about like railroading someone, all right? Talk about being denied due process. In my opinion, this is a grave and gross injustice as a defense attorney. It's to me, it's absolutely absurd. And I really feel bad for Lane because you just heard what happened. Completely ignored it, glossed over. Well, you got advisory. Do you realize how hard it is for me to go visit my clients in jail? I mean, it's ridiculous. It's like wow. I mean, I'm blown away.
Rule 15 stuff we're gonna, because you said last time that we were gonna, because we got to the end of the hearing last time, and there was only 5 minutes to go, and you said we'll talk about that at the next hearing, which would have been May 5th. And the issue is
What? Just tell me. I don't want to go deep into
I
that.
feel you. The 15.1 stuff, they didn't meet this. This does their witness and exhibit list does not meet the required standard of a Rule 15 witness list. It's just all boilerplate trash. Any and all is not. It's not. It's supposed to be the name, address, and any relevant written or recorded statements of the witnesses. It just gives their name. Then it's supposed to be lists intends to use at trial, lists obtained from or belong to. You got to make an extra list. Saying any and all photographs, that doesn't tell me what photographs you have that you might
Right.
use. That doesn't tell me what police report. You need to list out, we have these police reports. Now, we might use all of these, or we might use any of these, or that you can use any and all when you actually put a tangible list of items. Just to say any and all body worn. Well, how do I know which any and all you're choosing from? How do I know
Okay, I
what any
understand.
and all you're choosing from?
All right, I understand. Counsel.
Your Honor, so we send a copy of all the disclosure. So it's the disclosure he has. We can continue to modify our strategy for trial. And so as we get closer to trial, then we file a list that narrows it down to say these are specifically the things we're going to be using. But right now, he's getting everything that we could potentially use because we're sending it as disclosure.
Hold on. Is there a deadline by which?
Yes, it was May. It was the hearing with Judge. What was his name? Judge McDonald.
Correct.
Yeah, and I tried to enforce it then, and she at that up to that hearing she hadn't done this.
Yeah.
But at late at night on that day she forced this into the court. And if you pull up Rule 15.1 right now, she's wrong. It literally says name, address, any relevant written or recorded statement of the witness. All this says is Detective Eric Brown, case detective. That doesn't say name, address, and any irrelevant written or recorded statement of Eric Brown. And then when you get to the other list, and it's clear
there aren't going to be any recorded statements of the detective.
I mean, then that should say that. It should say that there is or isn't witness written, whatever. Okay, but it should say name and address, which, I mean, he's the police department. And so, but when it comes to any and all photographs, it needs to list what photographs they have. And this is where they get this scattergun approach. They give it to Parvin. And no, listen, I've beat these people in multiple cases already on this very same reason. I had them set up to get held in contempt, and they dismissed the cases in justice court. Because they're not physically capable or intellectually capable. I don't know what it is. I don't want to disparage them, but I'm just telling you, I've been going through this with them for 9 months. The same with Matt Walker sitting over there. It took him 5 months to give me the witness list that he was doing 30 days. And so he about got the case. Riojas ordered him to turn all this over by 5 p.m. that day, or the case was getting dismissed. And that's one reason that we're sitting here today, is because I embarrassed him in court.
Your Honor, may I speak?
But hold on. The point is this needs to be more detailed. There's no detail. This is boilerplate. So you've been around long enough to know what boilerplate is.
I know. I understand, Mr. Myers. Hold on. Go ahead.
Oh my God.
Your Honor, this is the same type of list that we file in every case. He has the information, so we've sent the disclosure. So he has the police reports. This is not a voluminous case where he's got hundreds of pages to dig through. It's very simple as far as the police reports in this case, the videos in this case. It's a very short witness list. And so he is on notice of the information. It's any of those videos, and we've disclosed the videos, and we continue disclosing the information. And as we come upon new evidence we want to use, we will disclose it in due course. So he has it all. So this isn't something where I understand that he's upset he doesn't have the media in his
No, Your Honor. I don't have the emails. You do not lie under oath. You're already getting a bar complaint.
So
can he leave?
Okay.
No.
Why can't he leave?
But
He needs to leave. He needs to leave.
so
He's lying. And I'm going to outburst.
Mr. Barber, I'm going to allow you to leave. Yes, not you though. Yeah, I'm relieving you.
Making sure that, and I just want to clarify that I am going to go make sure arrange. I need to that he has everything again.
Stop saying that.
Okay.
Can you hold him in contempt? He needs to be held in contempt.
No, you need to be respectful to him.
No, he's lying.
He's just talking to me.
He's lying.
If anything was missed, we redisclosed him at the jail. I'm going to arrange for absolutely everything a second.
Your Honor,
They're both saying that I have
Okay.
this stuff. I don't have it. Where is it? Am I hiding it in my sock?
Mr. Myers, you've been doing well, and you're getting a lot of
because
control.
I can't stand these people lying.
Okay,
and you're not doing anything about it.
Hold on.
If I lied, I get in trouble.
Let them talk. Go ahead.
Your Honor, we sent disclosure
Thank you, Mr. Parvin, for your
to
assistance.
Mr. Parvin because he was the attorney on the record on the first case when we sent the disclosure, and then he was the attorney on the second case. And so I am happy to have we will send all the paper disclosure. We'll just
Yeah, do that.
The emails,
I
all
know
that.
we'll just send that directly to Mr. Myers
Thank
at
you.
the jail. The
Thank
media, we will make sure his advisory council has so he can play that for him. And then when we're having a meeting, if something needs to be played for him, I can do that.
And with respect to your witness list,
So that was 5450. Guys, I promised my son that I would take him to the martial arts supply place. So I'm going to cut it at this point. But remember, we were at 54. Hold on, stand by. Around 5450. Let me write this down. Because I still have to do Reluctant Prophets video as well. So we're going to stop at 5450. We'll come back and we'll finish. This is a public services video. And then we'll do 5450. Thanks, Greg B. What's the matter, you? 5150. No, that would be me. I'm the 5150 lawyer around here. But by the way, guys, in closing, I got to tell you something. It was a blessing in disguise that the court admonished Lane, right? That if you don't behave yourself, I'm going to deny your right to represent yourself, because basically Lane sounds like a lawyer now. I mean, he does have a few outbursts because he's not perfectly trained. I'm telling you right now, Lane is killing it. His substantive arguments are on point. He aside from, just lack of experience, he's doing a great job, and I'm very, very impressed with what I'm seeing. Because when Lane doesn't cut people off and allows them to finish, it makes him look more professional, because his arguments are very good. I mean, he knows the substantive law, and I believe that on substantive law alone, he's going to win this. Probably, unfortunately, only on appeal, because you can tell that the prosecutor is going to do everything she can to make sure that she gets this conviction. And I guess that's her job. I think her job is to do justice, not just to get convictions. And I think that there were a lot of things done to Lane that were unfair, and a lot of decisions passed down that were wrongly decided in this case. But I'm thinking he's doing a really great job, pro se, man. And thanks, F. I appreciate that. Look, I'm doing my best to try to just pass on what I know to you guys. I'm a pretty opinionated guy. My friends tell me that I'm right of Attila the Hun, but our founding fathers would have considered me to be a far left liberal. So think about that. I'm just a free man upon the land who cares about my fellow countrymen, my American citizens. And I took an oath to protect and defend the Constitution. And that oath means more to me than pretty much anything but my wife and kids. And I just want you guys to understand that I'm not getting rich off of doing these shows. And I'm putting my reputation on the line by supporting unpopular people like Lane Myers. So I appreciate all of the super chats, and I'm going to check it out, Greg B. So we're going to have some fun. So probably what I'll do is I'll come back tomorrow and I'll finish up this part of the show, and then we'll push on into Reluctant Prophets show that he did. And then hopefully on Friday, I'll be able to cover what's going on the Friday hearing as well. In the meantime, guys, I really appreciate you guys supporting my channel. Pick up a copy of my book. That would help support me a lot. My journey to becoming a practicing, if you can see it, my journey to becoming a practicing lawyer with no law degree or undergrad. It's $19.99. If you go to my YouTube channel, you can pick up a copy. Even if you don't want to learn how, it'll motivate you, because, look, I slept on park benches. I worked a 3 to midnight shift at Home Depot. I got a job as a volunteer at the prosecutor's office, ended up becoming an extern for the Court of Appeal, and became a superior attorney where my firm has collected more than $300 million in verdicts and settlements for injured clients, and more successful than most lawyers that I know with 20 years in practice, and a nice background in appellate law, civil rights. And so I think that I'm in a good position to talk about a lot of these things in Lane's case from the perspective of California or Texas law. Again, I'm not licensed to practice law in Arizona. I don't profess to give legal advice about Arizona law, nor do I want to. I'm looking at this more from general legal principles outside of Arizona, and then, of course, federal principles. And I think that this harassment statute is a joke. And I do believe that with the right attorney, that Lane will get that overturned. And I think that although he's got a bad relationship with his current attorney, or I guess Parvin or whatever his name was, I think that his motion was really good. And I think it was on point. And I think that Lane has a lot of issues on appeal. And I would hope that he doesn't, from my perspective, if he was my brother, I would never let him plea out to this. But from a lawyer's perspective, Lane has to look at the big picture, wife, dog, what kind of a deal are they going to offer him? And that's between him and his creator. So I'm not going to sit there and tell him what to do. You try being in jail and see what you're going to do. Anybody that puts him down, if he does take a deal, you're a joke, because you don't know what it's like if you've never been in jail. It is the worst possible position you could ever be in. And that's by design, because they want to get their plea deal. That's what it's all about. So with that being said, guys, make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. Yeah, that's right. Everybody say a prayer for Lane. I know that he's, what's the matter? You says the picture on my book is my grandfather. I had a friend of mine do the artwork. Hopefully I'll look like that in 20 years from now. Sorry, guys. You guys crack me up. And I hope that he doesn't, just because I look, everybody, Lane Myers, the modern Braveheart of the law field. I mean, he is really, I'm impressed, and I wouldn't do these shows. I don't bestow compliments lightly, especially on pro per litigants. Aside from some of the civility issues that I have with Lane, I think that he's a genius. And I think on the substantive law, he's correct based on what I've heard. And I don't know if he believes in God, but my family prays for him. And I encourage that all of you guys pray for him and his family, because he needs the power of prayer. Spiritual energy is real. And there is a God. And people like me are there because we were called to try to help people like Lane. So with that being said, make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. I'll see you guys tomorrow. Hopefully you guys are liking my show. If there was a way that I could make money on YouTube, I would probably just do YouTube all the time, because I think that it really helps people like you understand what's really going on out in the real world. But God bless all you guys. Take care. Bye.